3, 4.
All right, everybody, we got some remedies tonight. We're doing a reading of Stone versus North Carolina Department of Labor. It's another twist on consent to sue against the government. So another government sovereign and qualified immunity case, but this time with a state statute that allows the government to be sued as part of the statutory construction of that state. So it's a North Carolina Supreme Court case from 1998. Which word is the justice who wrote the opinion? And here we go. Plaintiffs commenced this negligence action against the North Carolina Department of Labor pursuant to the Torts Claim Act of North Carolina, which is General Statute subsection 143 through 192, 1993. Defendants moved to dismiss. The Deputy Commissioner Alston denied the motions. The full Industrial Commission affirmed. The Court of Appeals affirmed. Because these claims arise upon defendant's motion to dismiss, we treat plaintiff's factual allegations as true. On 3rd September 1991, a fire started in a hydraulic line near a deep fat fryer in the Imperial Food Products chicken plant. The fire spread rapidly through the interior of the plant. Plaintiffs are either former employees of Imperial Foods who suffered injury in the fire or personal representatives of the estates of employees who died in the fire. Employees could not easily escape because the exits from the plant were unmarked, blocked, and inaccessible. After the fire, defendants conducted their first and only inspection in the plant's 11-year history of its operation. Defendants discovered numerous violations of the Occupational Safety and Health Act of North Carolina, OSHA, included the plant's inadequate and blocked exits and inadequate fire suppression systems. Defendants issued 83 citations for violations of OSHA North Carolina standards. Plaintiffs allege that defendants had a duty under OSHA North Carolina to inspect the plant. Defendants breached that duty by failing to inspect until after the fire. Defendants' breach caused plaintiffs injuries or deaths, and plaintiffs' injuries or deaths entitle them to damages in tort. The Tort Claims Act provides the state is liable, quote, under circumstances where it, if a private person will be liable to claim the claimant in accordance with the laws of North Carolina. Defendants contend that they are not liable to plaintiffs because under the public duty doctrine, they owe no legal duty to the individual plaintiffs. Defendants assert their obligations to inspect workplaces in North Carolina serve as the public at large, not individual employees. Plaintiffs assert that the public duty to serve doctrine does not bar plaintiffs' claims because it does not apply to the liability of a private person, and under the Tort Claims Act, the state is liable if a private person would be. We disagree, and we reverse. Private persons do not possess public duties. Only government entities possess the authority to enact and enforce laws for the protection of the public. If the state were held liable performing or failing to perform an obligation to the public at large, the state would have liability, but a private person could not. The public duty doctrine, by barring negligence actions against governmental entities absent a special relationship or a special duty to a particular individual, serves the legislature's express intention to permit liability against the state only when a private person would be liable. Our determination of legislative intent is also guided by certain canons of statutory construction. Acts in derogation of sovereign immunity should be strictly construed. In passing the Tort Claims Act, the legislature incorporated the common law of negligence. The public duty doctrine forms an integral part of that common law. Until a legislature clearly expresses that immunity is to be waived even in situations in which the common law public duty doctrine would otherwise apply to bar a negligence claim, we conclude that the Tort Claims Act incorporating the existing common law rules of negligence, including that doctrine. Plaintiffs argue that even if the public duty doctrine applies under the Tort Claims Act, it applies only to claims against local governments for failure to prevent crimes. When the court first recognized the public duty doctrine, it discussed the doctrine in terms of the facts before it. In the context of a claim against a sheriff, we explained that under the doctrine, a municipality and its agents act for the benefit of the public, and therefore there is no liability for the failure to furnish police protection to specific individuals. Once this court recognized this doctrine, however, our Court of Appeals applied it to a variety of other local governmental operations and to a state agency. While this court has not heretofore applied the doctrine to a state agency or to a governmental function, other than law enforcement, we do so now. The policies underlying the recognition of the public duty doctrine in Braswell support its application here. We explained that the doctrine was necessary to prevent an overwhelming burden of liability on governmental agencies with limited resources. We stated, quote, "The amount of protection that may be provided is limited by the resources of the community and by the considered legislative executive decision as to how those resources may be deployed. For the courts to proclaim a new and general duty of protection in the law of tort would inevitably determine how the limited police resources should be allocated and without predictable limits." Also quoting from a New York case, "A government ought not to be free to enact laws for the public protection without thereby exposing its supporting taxpayers to liability for failures of omission in its attempt to enforce them. It is better to have such laws even haphazardly enforced than not to have any of them at all." Further, we do not believe the legislature intended to impose a duty upon the agency to each individual worker in North Carolina. The most the legislature intended was that the division prescribe safety standards and secure some reasonable compliance through spot check inspections as often as made practical. Because the government entity owes no particular duty to any individual claimant, it cannot be held liable for negligence. Absent a duty, there can be no liability. In Braswell, this court recognized two exceptions to the public duty doctrine. Quote, "To prevent inevitable inequities to certain individuals." It explained that the exception to this doctrine exists, one, while there is a special relationship between the injured party and the governmental entity, and two, when the governmental entity creates a special duty by promising protection to an individual, the protection is not forthcoming, and the individual's reliance on the promise of protection is causally related to the injury suffered. These exceptions are narrowly construed and applied. The North Carolina General Statute provides that the Commissioner of Labor is charged with a duty to visit and inspect at reasonable hours and as often as practicable all of the factories, mercantile establishments, mills, workshops, public eating places, and commercial institutions in the state. It also imposes on the Commissioner a duty to enforce these inspection laws and require the prosecution of any violations found. It creates no private cause of action for individual claimants under OSHA. Although Section 95-4 imposes a duty upon defendants, that duty is for the benefit of the public and not for individual claimants as here. Plaintiffs' claims thus fall within the public duty doctrine, and to state claims for actionable negligence, plaintiffs must allege facts placing the claims within one of the exceptions to the doctrine. They make no such special relationship or special duty allegations. These claims, therefore, must fail. The dissent asserts that we have eviscerated the Tort Claims Act, nullified it, and rendered it obsolete, left it purposeless, and absolved the state of all liability, and barred all negligent claims against the state. These assertions are hyperbolic and overwrought. A myriad of reported and unreported cases covering a great variety of fact situations have allowed recovery against the state under the Tort Claims Act. Nothing in this opinion even hints at overruling those cases. Absent legislative change, the Act functions and will continue to function as it has for almost half a century. We simply hold, with sound reason and substantial grounding in the law of both of this and other jurisdictions, that in this limited new context not heretofore confronted by this court, the Act was not intended to and does not apply absent a special relationship or special duty, revised, reversed, and remanded. We have Justice Orr dissenting in the opinion. The majority opinion erroneously takes a limited and obscure common law concept, the public duty doctrine, which has traditionally applied only to municipalities and their law enforcement responsibilities, and expands the doctrine's application to effectively eviscerate the Tort Claims Act. The recognition of the public duty doctrine in this country is traced to South v. Maryland, an 1855 case. The case involved a negligent suit brought by plaintiffs to recover against the sheriff for failure to keep the peace and protect the plaintiffs. The court stated in that case, quote, "Actions against the sheriff for a breach of his ministerial duties in the execution of process are to be found in almost every book of reports, but no instance can be found where a civil action has been sustained against him for his default or misbehavior as conservator of the peace, and those who have suffered injury to their property or persons through the violence of mob riots or insurrections." The court went on to examine several earlier British decisions and concluded that because no special right was alleged, the cause of action failed. In reviewing the seminal decision and other authorities, I find no common law basis for the majority taking the public duty doctrine beyond the original bounds of local law enforcement. To the extent that other jurisdictions have bent and skewed the common law to expand the doctrine, we should not follow such an ill-advised course. The public duty doctrine, moreover, should not be applied here because, unlike in Braswell, this suit was brought under the Tort Claims Act. The public duty doctrine should not be used to grant the state immunity when the state expresses the intent of the Tort Claims Act was to remove immunity and make the state liable for its wrongdoing. It is patently unreasonable to interpret the Act's requirement that the state be treated like a private person as absolving the state of liability. The very reason for the language is to eliminate the common law doctrine of sovereign immunity. The majority's second argument that the Act incorporates the public duty doctrine because it incorporates the common law is also erroneous. The public duty doctrine is widely accepted by most state courts. While most states abolished sovereign immunity by statute, the doctrine came under attack. Some state courts abolished the doctrine, arguing that it was simply sovereign immunity under another guise, and to apply it would be inconsistent with the statutes that eliminated that immunity. Other states limited the application of the public duty doctrine to apply only in situations involving police protection. In North Carolina, the common law tradition of the public duty doctrine was never extended by this court beyond its limited application to municipalities and law enforcement. This court only recognized the doctrine for the first time in 1991. To argue, as the majority does, that by enacting the Tort Claims Act in 1951, the legislature somehow incorporated the expansive public duty doctrine enunciated by the majority is at best simply wrong. In its third argument, the majority asserts that Braswell rationale of preventing enormous liability on agencies with limited resources applies here as well. Damages are capped under the Tort Claims Act at $150,000 for causes arising on or after 1 October 94. Thus, the majority's fear of an overwhelming burden of liability has already been directly addressed by the General Assembly. In Braswell, there was a potential for overwhelming and unlimited liability because the plaintiff was claiming the police failed to protect her from an unpredictable criminal act. In this case, we are dealing with inspections that are required to be carried out on a regular, predictable basis. Here, the duty to perform is clearly set out and can be accomplished. It is feasible. This case does not involve determining how limited police resources should be allocated, as was the issue in Braswell. Instead, this case is more similar to what we differentiated in Braswell, where we stated that dealing with police resources was quite different than the predictable allocation of resources and liabilities which public hospitals, rapid transit systems, or even highways are provided. Justice Fry joins in the dissenting opinion. And that's the only remedies case and reading we have for today, folks. So there's your remedies. Have a good early evening, everybody.